I do have skills that make me a nightmare for people like you.
Taking out the motorway, southern city bound, heavier times from Papakura to Green Lane, 52 minutes from Dream. Northern's busy from Greenwell to Oniwa, 24 minutes from Constellation.
Ladies and gents, good morning. It is the 25th of January. We're heading into Waitakere District Court this morning. We're going to go in and find out about this entering a plea thingy that they want me to do, which is all fine. My intent isn't to go in there and cause any sort of disruption or upset anybody or cause an offence to anybody. I'm just going in to enter a plea. How they behave is up to them, but my intent is to willingly and knowingly and voluntarily enter a plea. As to what that will be will completely depend if they can prove to me that they had the right in the first place to issue that infringement from the get-go, given that their own policy states they shouldn't have. So if they want to keep doing this, we will see. Either way, if push comes to shove, I'm not going to go in there and argue about being a person or a man or any of that bullshit. You know, I'm in there playing a role. My role is going to be the alleged, and then following that, the defendant. Because I'm only alleged at the moment, it's only upon entering a plea that the proceedings are commenced and so forth, and that's when the rest of it happens. That's when you become the defendant. But up until that point, we will see what happens. I'm hoping the court security will behave themselves. Again, you know, I've got no intent to cause any disruptions, but I will make sure everybody follows their own bloody rules. There you go, mate.
I'll just pop the stuff underneath.
Oh, another one, eh?
Yeah, just pulls off. Yeah, so just. That's fine, sir. Thank you.
Thank you. Hope you like the attire. Something I thought would go well today given the circumstance, but yeah, it's just after 8:30. It's not till 10 o'clock. I want to get there around 9:30. Hopefully the traffic's not going to be that bad on the way in, and yeah, that way I can get in comfortably and have a seat and perhaps even catch up with the prosecutor if she's about and wants to have a word. That would be lovely. She could perhaps answer my question as to what she's doing. Anyway, catch you then. Have a good one, everybody. Right, we've just finished in court. For an hour and a half I sat there. For some reason my name wasn't on the screens saying where or what courtroom the matter was being heard in. I had to go up to the counter and ask them, and they told me courtroom 3. My name doesn't appear on the list. It's supposed to be scheduled for 10 o'clock this morning. Keen, KWN.
So I'm paid off for my. What's your first name?
Mark. Check this.
That's not meant that way.
courtroom 3.
Oh, is it? So it's not on the screen for a reason?
No, it's in courtroom 3, just downstairs.
Downstairs? Thanks very much, buddy.
Still possible to use the council section of the files converted to community law? Well,
Have a good day.
wasn't on the list. My guess is because they didn't want any members of the public that may have been coming in to watch to know where to find me. I went through, had to sit there and wait for the entire list to get called, then they recalled. And then before actually being heard, there was a lady before me. Now this was a lady that was born in 1950, so she's got some years on her, 69. And the allegation was that she rode a Harley Davidson through the Westmere Tunnel, which is where a lot of the hearings were about today, just speeding tickets in Westmere Tunnel, claiming that she had exceeded the speed limit. Now, she can't even get on the motorbike, let alone ride it. Numerous people ride the bike that's registered to her, but unfortunately New Zealand Police never sent her an infringement notice for the speeding offence. They never sent her a reminder notice for the offence. She first heard about it when she got a court summons 75 days after the alleged offence happened. She rightly pleaded not guilty, even though Selwyn tried his hardest to get her to enter a not guilty plea and guilty plea and just be done with it. But she was sticking to her guns. She'd never been in court a day in her life. Was trying to get Selwyn to give her some advice as to what to do, but of course we all know judges can't give legal, or JPs can't give legal advice. They asked her to go and talk to a duty lawyer, whose first duty is to the court, so that's not going to help her now, is it? But yeah, she was really confused, and I'd already asked her, and she asked for the photo. The photo shows a patched gang member riding a Harley, and only the back of him. It doesn't show who the actual rider or driver of the bike was. So it was really funny. She was totally confused, didn't know what to do. I'd already told her that what she needs to do is just plead not guilty and keep her lips shut, and then give me a call later. So I've given her my details, and hopefully she does that if she wants to actually win. I told her that she has the right to remain silent. They have the burden of proof, not her. Selwyn was trying to tell her that she can fill out a statutory declaration, but she can't in all good faith fill out a statutory declaration because she was first informed 2.5 months after the offence. She doesn't know who was riding that bike on that day at that time, but she knows it wasn't her. So as we know, the burden of proof lies on the prosecution. So if all they've got is a photo showing a patched gang member and not a 69-year-old grandmother riding a Harley, they're pretty fucked. They're going to try and use the presumption under the Land Transport Act section 133 that she's the registered owner and therefore liable, and she even said, well, I must be liable then. But she's only liable when they've convicted her. Until she's been convicted of that offence, she's innocent, which is what she has to stick to. So by all means, if she needs to contact me, she can do. We gave her the channel details, and she can contact me through email or whatever if she wants to. So because she kept looking at me for some sort of help, because I can understand, you know, she was, poor lady, didn't know what to do, she was confused. Selwyn was just trying word games and tricking her into getting, because he just wanted her to change to a not guilty plea, to a guilty plea and be done with it. But she had already, first and foremost, stood up and went not guilty, so a plea was entered, and she stuck to her guns, luckily. So she'll be going back. Hopefully I can get in contact with her and help her out. If not, so be it. But we've given her some information, and hopefully she can help her out. But because she kept looking at me, and every time she said not guilty, I would, you know, thumb up, and I was going like this, zip your lip. Selwyn noticed that and piped up in the middle of the matter that they were talking about with her and said, "Mr. Keane, will you please not speak to her?" I didn't say a word. And in fact, the police officer sitting behind me tapped me on the shoulder and says, "Why doesn't she just ask for a photo?" And I let rip on him and said, "She has. Otho shows no evidence. It's up to the prosecution to satisfy the burden of proof beyond a reasonable doubt, and she has the right to say nothing. And if you've got enough to prosecute her and find her convicted, you should have it without her uttering a word. So I had the cop talking to me, which got a little bit loud while they were busy yakking, and then Selwyn pipes up and addresses me first. Well, I don't know about you, but seeing he started the interaction with me, I had the right to redress and reply. So I said to him, I don't know who this lady is. She stood there and says, I don't know who this guy is. What are you talking about? And then he told her basically the options again, and she just seemed confused. Clearly, she had not been fully and fairly informed of the cause and nature of proceedings for her to make a plea. So she stuck to not guilty. Good on her. So yeah, after waiting for an hour and a half, hearing everybody's name getting called, and me sitting there eyeballing them both because they knew I was there, they knew who I was, I didn't even have to identify myself. He identified me in that courtroom by saying, Mr. King, please don't talk to her, accusing me of doing something I hadn't been doing. So he got a response. I don't even know her, Your Honour, and I haven't been, you know. If you're going to make claims like that, Selwyn, you best get your facts in order. Now, at the start of the proceedings at 10 o'clock, Selwyn made sure to reiterate no recording or video or whatever whatsoever in the courtroom. And then he, because of my response to Philippa Chapman, when I said to her, well, if Selwyn's gone ahead and put an order saying no recording whatsoever in the courtroom, how are you going to keep an audio recording of the hearing if he's made a direction saying no? And he's even stipulated it's an order of the court. Okay, I want a copy of that order, Selwyn, because all I've got is a direction, a draft from you saying no recording, and we've got a direction from Judge Glib, sticking to what Selwyn's draft was, but I haven't seen any order produced and signed by any judge saying no audio recording or whatnot. Why? Because it's a public courtroom, and we have all got the right to keep an independent record, independent of the Ministry of Justice's record of what's going on. That's why we can witness a public hearing. What they don't want is individual and independent records being kept of the crafty shit they get up to. So yeah, it was a bit of an eyeliner. All it was speeding tickets and people driving without a license. And instead of slamming them with what we threatened a lot, $1,000 fines, the police were happy to adjourn one matter for now the 5th time for her to go and get her license. Because they would rather those people go and get licensed than $1,000 out of their pocket for a fine for not being licensed, because then once they're licensed, they can make more money out of them for the rest of their lives with a driver's license. They're going to be paying all sorts of fees, and the court will make, and the justice and all the rest of it will make a lot more money that way than just finding someone for no license and hoping they get caught again to make some more money out of it. If it's a license, it's ongoing charges, registration fees, blah blah blah. So yeah, very interesting day. In the end, what's happened with my case is that I stood up and basically said, for and on the record, Your Honour, if the prosecution wishes to continue this vexatious and frivolous litigation against myself, then by all means, not guilty. Now, he wanted to go ahead and assign it straight away to a judge-alone trial in a couple of months' time, but Vanessa Olivier decided to stand up and pipe up her 2 bits. And she was worried about getting caught out in a technicality. So she pointed out to Selwyn that this court has no jurisdiction, or the judge-alone trial would have no jurisdiction in regards to this matter, and that she asked for the Justice of the Peace, Selwyn, to go ahead and make an order transferring it to the other jurisdiction to that point. So that way they were covered under a section, some section of the Disclosure Act, or the Court Proceedings Act or something. When I get the transcript, I will know exactly what she was referring to. Thanks for the extra little bit of information that I will be keeping an eye on in the future proceedings. So he stood it down for 2 months until the 18th of March 2019 at 10 o'clock. I don't have to attend that because it's solely for, literally in 2 months' time, there's another court hearing for them to then assign it to a judge alone trial, and then for the judge alone trial to assign a date after that. So it might not be until May, 4 months down the line. More fun I'm going to be having with Auckland Transport during that time, and a hell of a lot more time for me to gather more evidence against their frivolous and vexatious litigation, their alleged offence, which never should have been issued in the first place, to fuck around and play with them more. I mean, I'm sure I'm going to be having some responses from John Strawbridge by then, but the fact that they have chosen not to withdraw the matter and continue, after being numerous times informed that it should never have happened, that they should never have issued it, they're going to be taken to the woodshed big time. With the amount of evidence that I've shown everyone that's interested in this case, and even with people that I know that work as parking wardens, that I've shown what's been handed to me, they have all said the engineering's not up to scratch, the road markings were an error, the infringement never should have been issued. So the fact that they want to stick to their guns and continue to try and prosecute me vexatiously and frivolously just because they can't be the bigger guy and say, our bad, our apology. How much rope do you want to hang yourselves with is my only question to Auckland Transport. Because once this ends up being dismissed and found, you know, without merit in the first place, should the judge stay in honour and act impartial and as an adjudicator when it actually finally goes to a defended hearing, and it will do unless the prosecution withdraws, all of that is going to be evidence for me to then file a civil prosecution against Auckland Transport for bringing a frivolous and vexatious allegation against me when their own rules say they should never have done it. So it's up to you, Auckland Transport. It's up to you, John. Are you going to re-review this and get this shit sorted? Or does Auckland Transport want to be shown for the thousands of dollars of taxpayers' money that you guys are going to waste trying to prosecute me for something that never fucking happened, and no witnesses ever even shown that I was, and the charging document says person in charge of FAN 394. I wasn't in charge of a registration plate, and there's more than one person registered to be in charge of that registration plate, so how are you going to pick? So I am so looking forward to it. 4 months time. Steve, you want to be honest, you want to respect the trust and confidence that road users have in Auckland Transport, you stop doing this fucking shit right now. Because I'm not the type of guy, that entire courtroom, I had security come in when my name was called. Now, after the lady with the Harley had walked out, a friend of mine who was also with me went out and had a quick word to her and made sure she filled her in on a few facts. And while she was out there, our little short security officer, the Chihuahua, was sitting there yelling out to the rest of the court security officers, I want him out. That's what she was saying. That little Chihuahua puppy outside courtroom 3 was telling all the Oompa Loompas, get him out of here. They did not want me in that courtroom. They did not want me anywhere near that building. God help them, someone that actually knows their fucking rights and how to play their game, actually show up in their courtroom and challenge them. Unbelievable. So yeah, I've got an independent witness showing the court security saying they want me fucking out. Perhaps that could have been something to do with me standing up after an hour and a half of waiting, seeing the judge had already addressed me by name. He knew I was there, and saying, when am I going to get called? Because my name's not on the list. And he confirmed, you're on the list. Am I? Then why isn't my name being called? Why isn't it up there for public viewing? Unbelievable shit. So, fun times to come, people. You can rest assured that I am going to be the most tenacious, nitpicking fucking prick out there. I am going to show them for every fault they do. And God help them if they want to continue this. They will only be giving themselves more rope for me to hang them under civil prosecution for bringing a wrongful fucking charge against me. It's that simple. And I've got ample evidence to show that the prosecution has been supplied evidence and facts to support there was conflicting road markage and it should never have been issued according to their rules, according to their training manuals, according to their policy, let alone the law. So, end of. I'm going to stop now, and I will catch up with you guys, no doubt, in the next part, which will no doubt be part 17 by now. This can be part 16. So I will catch up with you all later. I hope you've been enjoying following. It isn't over by any stretch of the imagination. It just amazes me that it's going to take the Ministry of Justice 2 months to have a hearing to decide when I can have a hearing with a judge. They're going to put a parking infringement notice in front of a judge because justices of the peace are not trained enough. That's what it boils down to. So why else would a justice of the peace not deal with a simple parking infringement otherwise? Have a good day. Catch up with you next time on about keep cool to after school. See ya. Oh, and none of them had any issue with me wearing my jersey. They all had their badges on. Everything was wonderful. Nothing but polite and courteous behaviour from the court security, other than the little chihuahua being overheard. Get him out! Really should watch what you say in earshot of public, sweetheart. Alright, catch you later guys. Bye.